Hello friends, in the series on the income tax cases, today we will discuss a case which talks about all the system of filing the return of income, and this case is the perfect example that the assessee has to bear the cost of very costly litigation even if there is no fault of the assessee, even if there is no option for the assessee to fill the right column, and even the income tax officers and even the first appellate authority does not want to give the relief on the subject which is not in control of the assessee and for which the assessee is eligible, and only because of non-application of the mind of the officers even at the level of assessing officers and the CIT appeal, the assessee has to travel and go through a very lengthy litigation process. The name of the case is the Presbyterian Church Cooperative Credit and Thrift Society Limited versus Income Tax Officer. This case has been reported in 112 ITR Tribunal at page number 289, and the date of the judgment is 25th April 2024. In the present case, the assessee is a cooperative society. The assessee object was giving money as a loan to its members and earning interest. And as per section ATP subsection 2 clause A clause I, the assessee is fully eligible to claim the deduction of this income. If we go through the definition of section 2 clause 31 which defines person, then according to that definition, and in that definition the word cooperative society is not there. When the assessee was filing its return of income, the assessee chose the status as association of persons because there was no option for the assessee to choose the status of cooperative society. Otherwise, there was no fault in claiming the deduction under section ATP. But the deduction of the assessee was denied under section 143 subsection 1 without discussing any reason why the deduction under section ATP has not been correctly claimed. The assessee filed rectification under section 154 and made aware the assessing officer that there was no option to choose the cooperative society. So according to the best option, the assessee chose the status as association of person, since there is no cooperative society word in the definition of person according to section 2 clause 31. But the assessing officer didn't entertain the rectification application under section 154. So the assessee moved to the CIT appeal, and more interestingly and as usual, the CIT appeal also denied the deduction under section ATP. Friends, see the situation of the assessee, that there is no fault of the assessee. The assessee is 100% eligible for his deduction. There is no option to choose the status as cooperative society. So the assessee has to file the return. One of the option is to be selected, and if the assessee is coming forward and explaining his position that it was not possible for the assessee to choose the status as cooperative society, even then the CIT appeal denied the deduction. This is the very bad situation for the assessee, that even these type of appeals are not given relief by the CIT appeal. The assessee moved to the tribunal, and the tribunal said that there was no discussion about the reason that why the deduction under section ATP was not correctly claimed by the assessee. And the tribunal said that the present case is a perfect example where the deduction was denied on the basis of surmises and conjectures. The tribunal said that the mention of the status as an AOP did not disqualify the assessee to claim the deduction. The crux of the theory is that for small reasons which are not in the control of the assessee has to face such a lengthy process of litigation up to the tribunal level, which eats up assessee's 5 to 6 years costly litigation. The amount involved was only 5 lakh. So this is the case which should be brought to the knowledge of the law ministry, that how the officers are behaving, how they are passing their orders, and they are not entertaining the appeal of the assessee, which is to be plainly allowed to them. It only shows that they do not take the burden and they just try to shift the burden or to put the cap on the other hand. At the end of this video, once again I am repeating the name of the case. The name of the case is the Presbyterian Church Cooperative Credit and Thrift Society Limited versus Income Tax Officer, and this case has been reported in 112 ITR Tribunal at page number 289, and the matter has been decided by Jaipur ITAT SMC bench, and the date of the judgment is 25th April 2024. Thank you, friends.